going to talk about mediation. Mediation can be a great tool for resolving minor disputes. Things like a noisy neighbor, scheduling community events, use of the recreational facilities, etc. It can be used to foster cooperation and a professional relationship between you and your landlord. But it can also be used as a tool for bullying, intimidation, and getting tenants to agree to things that they do not have to and should not agree to. So be wary. Keep in mind that even if you believe your landlord or manager is acting honestly and in good faith, they are in the business of separating you from your money. And that is their major motivation for everything they do. So don't forget that. And even though the specifics of what you reveal in mediation are confidential, it can and may be used against you in the future. So keep that in mind as well. Mediation is not good for things involving your rights as a tenant under the Oregon tenant and landlord laws. So here are some advice and strategy that have been shown to be effective to protect a tenant if you are involved with mediation with your landlord. I'll start with mediation initiated by the landlord. Here are 18 recommendations. Number one, the mediator is not your friend. They are supposed to remain neutral. So be very suspicious if they say they're on your side. That is not their job. Number two, the mediator will not decide anything, and you don't have to agree to anything. Mediation does not need to result in any agreement at all. Mediation is merely a conversation that does not require a resolution. There are no winners in mediation, so don't try to win. Number three, and this probably should be number one because it is one of the most important things, insist that the parties remain at all times in separate rooms. Never let the landlord's attorney or the landlord talk directly to you, the tenant. The mediator must shuttle between the two of you. This is very important. They can do that physically by being in separate rooms, or if it's a Zoom mediation, the mediator can have you in separate rooms on the Zoom. But you need to make this very clear to the mediator ahead of time. And it's not an unusual practice. Mediators understand and are familiar with the concept of shuttling and should be comfortable in doing it this way. You can and must insist on this. It is extremely important to maintain that separation. This may be the most important thing I have to say here. 4, insist that if they, the landlord, initiated the mediation, they must state clearly what it is they want to mediate before the mediation begins, and preferably before you agree to the mediation. The landlord may insist or ask the mediator to insist that you, the tenant, give the reason for the mediation after they, the landlord, have initiated it. Don't fall for that. If that situation happens, if the mediator asks you, you respond as follows. They initiated it, not me, so it is up to them to let everyone know what it is they want to mediate. And then make sure everyone sticks to just the subjects they have listed and nothing else. Number 5, tell the mediator if the landlord threatens you in any way that it is inappropriate and it may be necessary to end the mediation if that occurs. Number 6, make sure the mediator understands that threats often come in the form of questions. I wasn't threatening, I was just asking a question. Often the form of the question is, does the tenant know that they could lose their home, or that they may have to go to court, or that they could get evicted? That's a threat. It's not a question. and it is a common form of threats, especially from landlord attorneys. Don't allow it, and don't let the mediator convey some threats. Number 7, tenants are not obligated to answer any questions from the landlord and should generally ignore questions from them. Demanding you answer questions is a form of bullying. One response is just to answer with a question. When are you going to comply with the law? But it's just better to avoid getting into asking questions back and forth. Just ignore it. Number 8, do not argue with the mediator, and do not allow the mediator to argue with you. Number 9, do not allow the landlord to pick their own mediator. And they will try to do that, and they will offer to pay for it. You must insist that they use the one from the local CDRC, which you're paying for. They are trained as mediators, not litigators, which is always going to be better for the tenant. No matter how strong the tenant's legal arguments might be, mediation is not litigation and not the time to reveal the tenant's legal strategy, arguments, or evidence. Keep that to yourself. Often landlord attorneys don't want to mediate, they want to litigate, especially with folks who are not experienced or prepared for litigation and under circumstances where the usual rules of litigation that keep them in check do not apply. Do not engage in legal arguments. It is not appropriate in mediation. Landlord attorneys will try hard to use mediation for pretrial discovery as well. This is not the purpose of mediation. Do not reveal arguments, evidence, or strategy. Save it for court if necessary. Tenants' possessions should be generally, the landlord needs to obey the law. This is what the tenant should be talking about. How can I get the landlord to follow the law, not what the law is? Okay. Number 11, ignore the landlord's legalistic arguments. This is mediation. Again, not litigation. Those sort of arguments are just a form of bullying. Number 12, while it might be helpful to reveal your legal arguments, strategy, and evidence to the mediator, make sure that the mediator keeps that information confidential. Mediation is not the time to reveal this information to the landlord and especially to their attorney. Nobody wins at mediation, and you are not trying to win, and you shouldn't try to win. Number 13, again, mediation is not arbitration or litigation. This is not a case to be heard and or decided by the mediator. If you hear your landlord or their attorney use those terms, it is clear they are not there to mediate. They are there to try and intimidate you. So act accordingly. And if you hear your mediator using those terms, this is a case, I'm hearing it, I'm going to decide. You need to be concerned about that mediator. Mediation is a conversation, and it absolutely does not require any resolution. If there is a legal answer or solution, mediation is not appropriate. 14, if at some point you are feeling intimidated, overwhelmed, etc., it is okay to stop the mediation, and you can finish it at another time. 15, it is okay and not unusual to walk away without any agreement. 16, you, the tenant, do not have to agree to anything. 17, the tenant does not have to compromise on anything, and especially you do not have to give up any rights you have under the law. So those are general advice, suggestions for a landlord-initiated mediation. I'll give you some more advice. When it is you, the tenant, has initiated mediation. Number one, try to implement all of the above recommendations and caveats. Number two, if you have initiated the mediation, you set the agenda. Make sure the focus and discussion remains on your agenda. Stick to your agenda. Don't let the mediator, or especially your landlord, hijack the agenda or the mediation. If they, the landlord, want to mediate something, they can initiate mediation on their own about that. Number three, try to stay away from legal arguments or justifications. Okay. Four, insist that the landlord must obey the law. There should be no argument about this, without arguing what the law is or what it requires them to do. If absolutely necessary, state what you believe the law is or what they are required to do, and insist that that is not up for debate or argument. That is just your starting point. But again, it's really best to try to avoid talking about the law, because they or their attorney will talk circles around you, it, and especially the mediator. And often mediators have no idea what the law is, and they're going to go with whatever the attorney says. So just try to avoid that. Number five, again, you don't have to agree to anything. Number six, you don't have to compromise anything. Number seven, it's okay and not unusual to walk away without any agreement. If they're using an attorney, you should have one as well. Make sure your attorney is familiar with all of these caveats and follows them. Mediation can seem cooperative or friendly, but don't let your guard down. If the discussion seems to be going off someplace you are not comfortable with, end it. Finally, is it a good idea to give the mediator a copy of these suggestions so they understand your concerns? You should also instruct the mediator that this is confidential information as well. I will make these guidelines available in written form with this video. I think this covers the essentials on mediation. Good luck.